Good evening, everyone. My name is David Morris. I'm chair of the Brandeis Lawyers Alumni Network. I'd like to welcome you all to tonight's discussion. In a few minutes, we'll hear from our panelists on the philosophy and history of Jewish law and its effect on law in the present day. And we'll have some time for your questions towards the end. This event is co-sponsored by the Department of Near Eastern and Judaic Studies, the Legal Studies Program, and the Brandeis Lawyers Alumni Network. Before I introduce our speakers, I'd like to go over a couple of housekeeping items. Aside from the speakers, all participants are muted on the call for now. If you have questions for the speakers, please use the Q&A function to enter those, and we'll do our best to get to as many of them as we can towards the end of the session. Now it's my pleasure to introduce Professor Lynn Kaye, Professor Alexander Kaye, and Justice Sheila Sonnenschein. And for quick intros, Lynn is the Associate Professor of Rabbinic Literature and Thought at Brandeis. Her areas of interest include rabbinic law and narrative, the philosophies of time, legal theory, and critical and literary theory. She completed her master's in the Hebrew Bible at the University of Cambridge and her PhD in rabbinic literature at NYU, during which time she held fellowships at Cardozo Law School and NYU Law School. She completed the graduate program for women in advanced Talmudic studies at Yeshiva University, and her 2018 book, Time in Babylonian Talmud, was a finalist for the National Jewish Book Award. Among other topics in Jewish legal theory, practice, and texts, she writes about strategies of ordinary Jews in the Talmudic courts. Alexander Kaye is the Carl, Harry, and Helen Stoll Chair of Israeli Studies at Brandeis. His research deals in the history of Jewish thought with a special focus on political thought, the history of law, and theories of Jewish modernity. He's also an expert in Israeli studies and focuses on the relationship between law, religion, and politics, and in particular, the history of religious Zionism. He's the co-editor of the Journal of Israeli History. His latest book, The Invention of Jewish Theocracy, The Struggle for Legal Authority in Modern Israel, was published in 2020. And the Honorable Sheila Prell Sonnenschein has 50 years of legal and business experience, including 11 years as a full-time, neutral with JAMS. She's been recognized by the American Bar Association, the State Bar of California, the Orange County Bar Association, and the Academy of Matrimonial Lawyers for her various accomplishments. She's a much sought after mediator, arbitrator, judge pro tem, and neutral evaluator in a broad range of practice areas, including business and commercial, family, employment, real estate, probate and trust, malpractice, and appellate disputes. The judge served on the Orange County Superior Court, where she was the presiding judge for the family law panel. During her 16 years as justice on the California Court of Appeal in the 4th District, 3rd Division, she heard literally thousands of cases and published a multitude of significant opinions. She attended Brandeis from 1963 to 1964. With that, I'll hand that over to Lynn Kaye.
Thank you, David, for moderating this panel, and thank you to the sponsors of this very exciting event. I'm honored to be with my fellow panelists and with all of you tonight. I want to get started by talking about two interconnected things this evening to begin the discussion about 2,000 years of Jewish law. First, I'm going to define Jewish law for us as something more than rules. Its interpretation is shaped by the communities that practice and judge it. The rules create communal norms, social roles, values, and shared narratives about law's meaning and the identity of the people bound by it. So my first point tonight will be that Jewish law is more than rules. Then I will connect the definition of Jewish law with a case study for the challenges of being a judge in the classical Talmudic period, which is the first half of the first millennium of the Common Era. I'd like to consider together the issue of judicial advocacy or legal advice to people who appear before a rabbinic judge. With the label judicial activism often traded as criticism by different camps in the US polity today, it's an interesting time to think about perspectives that ancient Jewish law can offer on the role of judges. So to begin, I'm going to just bear with me. Robert Cover's description of law in general has been enormously influential in academic studies of Jewish law over the past several decades, because while Cover used biblical examples to explicate a general theory of law, one which would apply to multiple coexisting normative communities in the United States, many find that his theory makes Jewish law and Jewish legal texts much easier to define and to understand as well. He wrote, "No set of legal institutions or prescriptions exists apart from the narratives that locate it and give it meaning. Law is never just a set of rules," in his opinion. "The stories that people tell about the rules, which explain them, which ground them, and which connect those rules to people's lives and values, are intrinsic to the category law." One memorable example that Cover cites is a biblical example, which is the rule that a firstborn son's portion in the Torah, in the Pentateuch, should be double. So if there's many children, the firstborn son would receive a double portion of the inheritance. So in Deuteronomy, that is the rule. Firstborn son gets a double portion of the father's household property. Yet, any readers of Genesis will remember that the stories of the patriarchs consistently depict heroic younger sons usurping the role of the firstborn. Ishmael, Esau, and Reuben are all relegated. So which is it? You cannot ignore the founding stories of the people of Israel, and yet the rules guiding how land would be distributed in that population contradicts those stories. So Cover's insight is that we need to study the laws along with the stories to see the meaning of the law and to understand the normative community that the law creates. Cover's insight gives theoretical language to my part of the academic field of rabbinic scholarship, which studies the narratives of Jewish legal collections as equally important as the rules and the reasoning that often get more attention. So the Talmud has many narratives about judging, and that's going to be in the second part now of my presentation. So in the Talmud, court proceedings are judge-directed and fact-finding. This is not an advocacy-based legal system. I understand that even in the late Roman Republic and early Roman imperial law, legal advocacy was not done by legal experts. It was a form of rhetoric, and it was informal, friendly court accompaniment until it was legalized by the Emperor Claudius in the 1st century of the Common Era. Now, by the 17th century, hiring lawyers in rabbinic courts was an established practice. And today there are advocates and lawyers in rabbinic courts. But Talmudic law from antiquity presumes that the judges are fact finders. They are not, and there are no professional advocates also appearing before the rabbinic judges. Cases are meant to be solved by judges discerning the proper ruling by questioning witnesses and examining other forms of evidence. Now, both of the Talmuds from Roman Palestine and from Babylonia show concern about judges crossing a line from a judge to an advocate on behalf of one of the petitioners that appears before them. The Palestinian Talmud, or the Talmud of the Land of Israel, seems more open to the advantages of judges offering legal information to petitioners, if this would help them to present their cases more successfully. The Babylonian Talmud seems to counsel caution on that. But Babylonian Talmud stories do show judges occasionally advising their relatives, their friends, and sometimes ordinary Jews as well, when they appear before them in judgment. In the wake of the Talmudic opinions that I'm summarizing for you, Maimonides, who is a towering figure of medieval Jewish law, offers the following advice to judges to help them maintain their position as an impartial finder of fact. He says, how do you know that a judge should not be an advocate? Because the Torah, the Pentateuch, says, distance yourself from lies. So his first idea is that there's something not honest if a judge advocates. So Maimonides continues, The judge should say what appears to him and then be silent. And Maimonides presumes only male judges in rabbinic law. He must not instruct either of the litigants at all, even if one of them brings a single witness. The judge should not tell that man, we do not accept single witnesses. Rather, say to the respondent, this one testified against you. And hopefully the respondent will admit what's being claimed and say, that's true. Unless and until the respondent himself argues he is a single witness and is not believed against me. So that first paragraph, Maimonides says that, in Jewish law, classically, only in most cases, only two witnesses are acceptable as witnesses. A single witness would not count. But the first paragraph suggests that even if a single witness, which is not admissible, is presented, the judge should not tell either the person bringing the witness or the person who the witness is testifying against that this isn't actually valid evidence. Rather, one can say, somebody said this, and unless the respondent is actually knowledgeable that that is not admissible, they could lead them to admitting what's true, that they did it or something like that, and then that would have ended up being that the judge didn't offer any counsel at all. The next paragraph, though, goes in a different direction. If the judge sees that a litigant is having trouble presenting a valid claim because he's unable to express himself logically, or is overcome with anger, which causes him to lose the thread of his argument, or if he makes mistakes as a result of foolishness, the judge is allowed to help the litigant a little by explaining to him the beginning of his intended claim. So if the judge can see that what the person's trying to suggest, but they're getting off track in some way, the judge can start them off. As it is written, open your mouth on behalf of the voiceless. However, concludes Maimonides, take great care not to act like an advocate. So these two paragraphs show a definite tension, and this comes from Maimonides amalgamating both Babylonian and Palestinian Talmudic views. But I invite each of you in the audience to consider, how should a judge, if they are the only legal professional, act in order to maintain fairness, but also act in the interests of justice? Both Talmuds include both Talmuds include hundreds of short narratives that show judges stretching and straining between fairness and justice, or fairness and compassion, when it comes to people appearing before them, many of whom are unnamed lay people who do not know how the law and the details that they know about in their cases might affect them. If you like, during discussion, we can talk about some examples. For Maimonides, making the right choice is left to the good judgment of the judge. So I'm about to conclude. This evening, I presented two ideas about Jewish law from its earliest stages in the time of the Talmud. The first is that Jewish law is about more than its rules, and even more than its legal argumentation. Its narratives, whether they are stories in rabbinic texts or the narratives of the communities who interpret and practice Jewish law, are integral to understanding the meaning of Jewish law. And the second idea that I mentioned tonight is that Jewish law has a rich tradition in its rules and narratives about the role of judges in accomplishing justice. The stories show rabbinic judges maintaining allegiance to legal traditions and the precedents that they inherit, and showing concern for the difficulties of the people appearing before them. Absent professional legal advocacy, Talmudic judges are charged with navigating a subtle distinction between judging the merits of two sides of a case and ensuring that each of those sides of the case have the advantages that the law might afford them. Returning to the traditions of classical Jewish law might provide a useful counterpoint in contemporary arguments about the roles of judges and judicial activism today.
All right. Thank you, Alexander. Do you want to go next?
Thank you very much. It's absolutely a pleasure to be here in this conversation. In some ways, the talk that I'm about to give builds on what Lynn just talked about. She showed that Jewish law is not simply a list of rules, but it's embedded in a series of narratives, in a culture, if you like, of a people. And I'm going to show similarly that Jewish law is not something that's a discrete sort of unit of laws unto itself, but it also exists in a historical context and in a social context. People often feel that Jewish law is sort of self-contained. Here's Rembrandt's Moses coming down from Sinai with the 2 tablets of the law. In the rabbinical tradition, these are accompanied by this is the written law, which is accompanied by the oral law. And you'll often hear it said by people who talk about Jewish law that basically this system has everything in it that is needed to run anything from individual lives to societies to an entire nation. For example, the state of Israel. And there are people that argue that the state of Israel, even today, as a modern democratic state, should be run by Jewish law. What I'm going to say over the next few minutes is that there are at least 3 ways of noting that Jewish law, not only today, but always has been in conversation with other kinds of political and legal institutions. In other words, it's not a discrete, hermetically sealed system, but it's a legal system in conversation with other political and legal systems. And I'm going to briefly touch on 3 ways in which that is true. The first is the way that Jewish law is in conversation and has historically always been in conversation with other kinds of Jewish institutions. In other words, within the Jewish community itself, Jewish law is in conversation with other kinds of authority, which is distinct from rabbinic law. The second thing I want to show is that Jewish law is in conversation not only with other institutions inside the Jewish community, but with other institutions outside of the Jewish community. And in fact, Jewish law is often in conversation with, it's often in collaboration with, and certainly always very knowledgeable about legal institutions that are outside of the Jewish community. And finally, I'm going to say a word or 2 about the state of Israel, because this is a particularly interesting test case about the ways that the context matters. In this case, in the case of the state of Israel, the context is a modern democratic state, and the way that Jewish law, as it operates in the state of Israel, has actually been affected and transformed in all kinds of ways because of its context in a modern nation state. So let me briefly take each of these in turn. When I talk about Jewish law being in conversation with other non-rabbinical Jewish institutions, and there are a couple of ways that this happens. The first thing to note is that I think it's a very common assumption that before the modern period, all Jews who by and large were what we would today call religiously observant. In other words, they followed Jewish law, and Jewish law they believed to be binding upon them. It held a central place in every Jewish community. And the assumption today is that simply the courts in Jewish communities were rabbinical courts exclusively. And Jewish law, halakha, was the law that governed every aspect of Jewish life. But in fact, that's not the case. It is certainly true that halakha, the traditional Jewish law, did play an incredibly important role, an authoritative role in the way that Jewish communities were run and led their lives. And indeed, most Jewish communities did have either within them or at least nearby, somewhere that they could have access to, some kind of rabbinical judge, and occasionally even a more extensive rabbinical court. But it's also the case that Jewish communities had non-rabbinical courts inside of them. In other words, even Jewish communities that were granted a kind of autonomy to govern their own concerns were not exclusively ruled by halakha, by rabbinical law at all. There were courts that were on which there were judges who did not necessarily have any rabbinical training, have any special rabbinical knowledge. And in fact, they were often there because they were the leaders of the community, often because they were wealthy individuals. And these courts, these lay courts, these non-rabbinical courts, often sat side by side with the rabbinical courts in particular Jewish communities. And the relationship between them varied according to historical context. Sometimes the rabbis were very much more powerful and dominant. Sometimes the lay courts were. And often there was a good relationship between them. This was very important, even from the perspective of the rabbis themselves, who appreciated this non-rabbinical kind of authority in the community. And one of the reasons for that is that Jewish law has very, very stringent standards when it comes to criminal convictions. And for example, there had to be two witnesses to any in any criminal prosecution, and the witnesses had to be adult males who are not related to each other. They had to issue a warning, an explicit warning to the assumed criminal before the act was done, and so on. And it's because of this very difficult to convict criminals according to the strict letter of halakha, of Jewish law. And for that reason, Jewish courts often essentially used the lay authority, the authority of the non-rabbinical courts, to sometimes come in and help achieve a conviction where a person was obviously guilty, but according to halakha, strictly speaking, they would not have been convicted. In other words, even rabbinical courts themselves made use of non-rabbinical laws and conventions in order to carry out proper justice. So that's the first example, and there's a tremendous amount to say about that. I'm happy to expand upon it later on. The first example in which Jews govern themselves by halakha, yes, but in addition to other kinds of law, the law of lay courts. Now, Jewish law also is not just a matter for the closed-off Jewish community, but Jewish law always has been in conversation with other kinds of legal system. Of course, Jews, for most of their history, most Jews have lived in wider societies that are not governed by Jews. For the past 1500 years or so, most Jews have lived under either Muslim or Christian rule. And Jewish courts were always acutely aware of the laws and the norms and practices of the Muslim or Christian or secular courts around them. And in fact, in places with a significant Jewish community, those Muslim or Christian courts were also acutely aware and very interested in the way that Jewish law worked as well. I'll give you just a couple of examples of this, of very, very many. This image is an image of the Pinkas, which is the name for the community register, basically the court records and the government records of a city called Metz, which is in France. And this particular image is of one of those registers from towards the end of the 18th century, in the decade or so before the French Revolution. And there's a professor called Jay Berkowitz who's written extensively about these records and shows that these records are certainly deeply based on Jewish law, but also evince a tremendous familiarity with the laws of the French courts and Christian law, which was observed by people around them. And indeed, in the Christian courts, which were right next to the Jewish community of Metz at the time, there was all kinds of familiarity with Jewish contract law and other kinds of Jewish legal tools and terms and so on. And in other words, the courts knew about each other and used each other's terminology and systems. And it's not just this is not limited to Christian contexts. Here is an image. The writing's a little small, so you probably can't see. This is an image that I know about because of the work of Professor Jessica Marglin from the University of Southern California. And these two images are actually the same piece of paper, but two sides of the same piece of paper. And this is a contract that comes from Marrakesh in Morocco in 1875. And it's a real estate transaction. And Professor Marglin shows that the two sides of the contract are basically similar to each other, except that one side is written in Hebrew and uses the terms of rabbinical law, and the other side is written in classical Arabic and uses the terms of Sharia. And this is because the people that carried out this real estate transaction, who wanted their transaction to be recognized both by Jewish courts, halakhic courts, and by Muslim Sharia courts. And so again, we see these two legal traditions very deeply intertwined. Let me close briefly by saying a word about the State of Israel. The State of Israel, as you probably know, has officially recognized rabbinical courts. These rabbinical courts have exclusive jurisdiction over the family law of all Jews living in Israel. And you may have thought that this is because Israel defines itself as a Jewish state. But in fact, that's not the case. There were rabbinical, even before the State of Israel was founded in 1948, when it was part of the British Mandate, and in fact, even before the British took over Palestine, when it was still under the rule of the Ottoman Empire, a Muslim empire. Under all of those jurisdictions, this particular territory has had family law under the exclusive jurisdiction of religious courts, be they Christian, be they Muslim, be they Jewish. And this was the case under the Ottomans, this was the case under the British, and it's still the case in the State of Israel today. So whereas the state recognizes rabbinical courts, it also recognizes Sharia courts, it also recognizes Christian courts to have exclusive control over the family law of their own communities. One thing, though, that has changed during the period of the State of Israel itself since 1948 is that the very fact of the existence of a sovereign Jewish state has itself had an impact on the way that Jewish law is carried out in the State of Israel. In other words, the context matters. Jewish law is not hermetically sealed. It responds to context, and in this case, even being in a Jewish state has an impact which changes in certain subtle ways the way that the law is carried out. Now, there are many, many examples of this, but let me just give you one example. You see here a photograph of the rabbinical judges on Israel's High Rabbinical Court in Jerusalem. And if you were, looking at this from a purely stereotypical point of view, you'd see a bunch of men who look like ultra-Orthodox men with beards and black hats, and you'd say that this is clearly an extremely conservative, very traditional institution. And indeed, in some ways, it is or has been for the past few decades. This is a high rabbinical court in Jerusalem, which is essentially a court of appeals for the other rabbinical courts in the State of Israel. So if a rabbinical court in, let's say, Tel Aviv or Haifa makes a decision, this court that you see pictured here can overturn that decision as a court of appeal. What's striking, though, is that there are, with very, very few exceptions, there has never, ever, ever been a court of appeal, an institutionalized court of appeal in Jewish law for the entirety of Jewish history until the 20th century in Palestine. This was essentially, again, with few and marginal exceptions, this is a tremendous innovation in Jewish law. And the reason it was set up is because the British, who were in control at the time that this institution was set up, believed that all courts had to have courts of appeal. All court systems had to have courts of appeal in them. And the rabbinical courts responded to that pressure, to that intellectual influence, and to that historical context to actually develop a way of setting up a court of appeal, even though by most readings, the halakha does not require, in some senses, even object to a court of appeal like this existing. So there are other examples which I'm happy to return to if people are interested. But the main takeaway point here is that I really wanted to emphasize the way that Jewish law is not a thing sort of sealed off in its own world, but is and always has been in conversation with other legal and political systems.
Hello, I'm Sheila Sonnenschein, and I'm happy also to be participating in this panel with Professors Alex and Lynn Kaye. I'm going to focus my remarks on contemporary perspective on 2,000 years of Jewish law. And I thought I'd start by giving you a little background on my Jewish background. I was born Jewish. My parents were happy to be Jewish, but I had no religious education actually until I became an adult. And that was premised on the fact that my mother didn't really appreciate organized religion. So as a result, I spent 5 years in Christian Science Sunday School, 7 years in a Protestant boarding school, and I attended a Catholic law school. I have a very well-balanced, if not particularly Jewish, educational background. I did become a bat mitzvah at 45, and that was with our third child, our daughter, and we were had our b'nai mitzvah, and that was already 10 years after I was on the bench as a trial court judge and as a justice on the Court of Appeal. The law's place in society and God's place in the law, I think, is fundamental to understanding the contemporary perspective of Jewish law. And the purpose of law, in my opinion, is to regulate behavior. And you regulate behavior by rules and by consequences and punishment. The first religion satisfied those goals. And when that didn't work perfectly, then we got the law and judges. Contemporary law, as far back as you want to define contemporary, has always relied on God in one aspect or another. In 1873, Mrs. Bradwell graduated from law school in Illinois, and she passed the bar, and she applied to become a member of the bar, and the Illinois State Bar said, not so fast. We don't think that women should be lawyers. So she took her case to the United States Supreme Court, and the Supreme Court agreed with the state of Illinois. And since there was no law per se that could be cited or no precedent, the court relied on God, saying God designed the sexes to occupy different spheres of action, and that it belonged to men to make, apply, and execute the laws. That is the paramount destiny and mission of women, are to fulfill the noble and benign offices of wife and mother. This is the law of the Creator, end quote. We still in contemporary law see examples of falling back on God or biblical precepts in order to decide or frame the issue on a case, including the right to die and choice. My judicial philosophy is very simple, and actually it ties in to what just Professor Lynn Kaye said, and that is the justice. I don't see that much of a dichotomy between fairness and justice, because to me, fairness equates to justice, and justice equates to fairness. And when you consider the mandate of justice shall we pursue, and then the way that that justice is achieved, it comes down to a question of being fair. And when I first became a judge, my Israeli father-in-law gave me a Bible with the inscription, "You shall not render an unfair decision, do not favor the poor, no show deference to the rich, judge your neighbor fairly." This then, in my opinion, is a Jewish legal system by definition. And fairly, in my opinion, is to start with the question and not the answer. In other words, as a judge, when you're determining the outcome of a case, you don't start where you want to wind up. You start at the beginning, and you look at the facts, and you look at the law, and then you can come to a conclusion. And that does not take into account advocating for anyone. It only takes into account what the parameters are within which you can make your decision. So what is Jewish law's relevancy in the contemporary world? From the beginning, in Judges, Judaism recognized you shall set up judges and law enforcement. this was a realization that having laws without someone to interpret them was meaningless. So as Professor Alex Kay said, Judaism sets forth a complete framework for living, including from conception to birth, from criminal to torts to business to taxes to the environment to property to contracts. And even as far as the death penalty, which Judaism prescribes, should be, there's no proscription against the death penalty, but the concept was if the courts imposed the death penalty, I think it was more than every 80 years, that was too often. So when I was on the bench, I wrote 2 cases that I think tie in very, very well with a lot of Jewish legal precepts, concepts. And I didn't realize this at the time that I was writing these cases. I didn't realize it actually until I studied to become a bat mitzvah and could see the correlation between what I was doing on the bench and the kinds of issues and I was determining and analysis that I had to make. So the first case involved legal service on a guard gate. I sue you, I try and serve you with the papers. You live in a guarded community or a guarded condominium in New York. How do I get service if you don't allow me inside the gate or up the elevator? And the underlying law in California at the time was that service is complete if you leave the process, if you leave the papers with a competent member of the household and a person apparently in charge. Our court held that appellants had authorized the guard to control access to them and their residence, and that was based on an assumption that therefore we could assume that the relationship between the resident and the guard ensures delivery of service. We held that litigants have the right to choose their abodes. They do not have the right to control who may sue them by denying them physical aspect. And kind of the bottom line moral of that story is that you can wall yourself in. You cannot wall out. You cannot wall the outside out. And Judaism is a community. Being part of a community, a nation, or a people is a huge aspect of the religion. We can't even pray unless we have 9 other Jews with us. The second case, and I think this also goes to Alex's point about the narrative behind, or actually I think that was Lynn's point as well. The narrative behind the rule is as important as the black letter of the rule itself. And in this case, again, involving people who lived behind a gated community. I can't see any of you, so I don't know if you're young, old. I certainly don't know where you're from. This is kind of intimidating to be talking to myself, but I know that that there are a whole bunch of you out there. I don't know how many of you are from California and are old enough to remember when we didn't have Prop 13, but Prop 13 changed the way that the basis upon which property taxes are assessed on residences. And prior to 1976, when the law was changed, this homeowners association predicated its homeowners assessment based on the assessed value of the property. In 1975, when the law changed, that didn't work anymore because the law at that time, it actually still does, predicated property taxes based on the 76 value unless there was a sale or transfer of the property. So what that resulted in this particular case was two homeowners, I mean, side by side, same exact property, same distance to the beach and to the other amenities within the community, and actually maybe even the same size of the house, were paying substantially different amounts in their assessment, because one was based on the 75 value of the house, assuming they were still in it, and the other was based on what they paid a year before. So they sued, they brought the issue to the court, and we looked at the narrative behind the rule, how the fee was to be assessed, and determined that the purpose of the assessment was to base it on the value of each home. But that purpose was no longer attainable because the method of assessment was no longer related to the value. So we determined that a flat rate would be the way to go in order to determine the assessment per home. Now, the Jewish law, through the Talmud and the Mishnah, have answered that same question, same question, but the facts were different, but the concept was the same. And in that situation, the question was, who builds the wall? And I'm not talking about the wall that we're all talking about now. I'm talking about the wall that walled the cities in back in those times. And the answer was, who builds the wall? Okay, so if we had a screen and you could see a bouncing ball, you could follow me. I'll start with number one. The poor closer to the wall give more than the poor who are far from the wall. The wealthy who are close to the wall give more than the wealthy who are far from the wall. But the wealthy who are far from the wall still give more than the poor who are close to the wall. I want to now turn my attention to a specific topic, which is ageism. And I'll tell you how I got into this. 25 years ago, when I turned 50, I was asked to speak to a group, a newly formed group within the Orange County Bar Association on elder law. And I had done a lot of speaking up until that time on gender bias. So I figured I'll just turn the sexism, gender bias to ageism. And so I've basically been talking on this subject for 25 years. Ageism is a deep and profound prejudice against the elderly and a systematic stereotyping of and discrimination against people because they were old. And with any ism, it defines people by generalities rather than specifics. So how does Judaism define old age? In the Torah, we have many examples of people living from anywhere from 110 to 175. The Mishnah gives many different definitions at different ages, including from strength at 30 to almost gone at 100. But at any age, the Judaism concept was that age or old age was predicated upon being healthy and viable and vibrant and able to live happily. The Judaism also differentiates to some extent between just reaching a certain age and the wisdom that comes with that. with a recognition that senility may affect the young as well as the old. The Torah, in describing how old a priest, when a priest has to retire, does not mention age specifically, but relates to physical blemishes. And later writings say that the priest could serve until they tremble. So ageism within Judaism, or age, exemplifies, in my opinion, some of the most basic aspects of Judaism in the law. First and foremost is the concept, as I said before, of fairness. You don't judge someone better or worse because they're rich or poor. This is just another way of saying that same thing. You don't judge people by their age, either because they're old or because they're young. You judge them by who they are. And the other, I think, very important concept of Judaism exemplified here is the concept of honor and respect. We respect our father and mother, and we're told that we need, as a society, to consider every man and woman as our mother and father. So it's not just a personal obligation, but a societal obligation. Society is judged by how it treats the elderly. And honor is not just it's a word with meaning and substance. How do you honor? How is the honor bestowed? It's more than just providing food and shelter and clothing. Those are the things that we have to do, but the meaning of honor is really the way in which that those actions take place. What is honorable? What is honorable is the promotion of self-respect, the enabling of people to feel that they're part of the human race and that they haven't been put out to pasture. We honor somebody by showing them respect, by recognizing that their worth. As we see in Numbers, when God told Moses, gather the elderly and have them help you deliver the people. It was a recognition for those people who were gathered. It was a recognition of their worth. The concept of self-respect, which comes under this concept, is a self-fulfilling prophecy for society and for the person. Because when society does something that recognizes the elderly, and I laugh every time I say that, because at 75, I'm definitely in that category. So to some extent, I'm talking about myself. But the self-respect is important because it becomes a self-fulfilling prophecy, as I said. And giving money is not necessarily the same thing as doing something that enables someone to have feelings of self-worth. Jewish law and Judges prescribes that the Talmud says an old man may not serve on courts hearing capital offenses. It doesn't define what old is, but Maimonides was concerned about the forced retirement added in the adjective very. A very old man cannot serve. And the reason for this in the writings is not necessarily because the scholars were concerned that someone was too old to make a decision, but rather the concern was that an older person may not be sympathetic to young people, and therefore an old judge couldn't maybe not be fair to a younger person. So this again goes back to the whole concept of Judaism and fairness. Why are society's perceptions of the old relevant today? Well, I mean, one thing I think comes to mind, number one, is employment discrimination. Ageism can prevent people from even getting any job or an appropriate job considering their background and abilities. And also totally relevant today is the whole concept of health rationing and whether we just let the old people die and get rid of them. And of course, who's going to get the vaccines. So in my last few minutes, I'd like to focus on price discounts and how those affect ageism and how it's tied to Judaism. In the 1990s, there were 2 cases that came out in California. One approved of banks paying higher interest to older people, and the other case approved of movie theaters offering discounts, so older people paid less to go to the movies. Both of these cases are still good law in California, and both the cases use basically the same rationale, which was everyone will eventually be entitled to those discounts. So that's not really discriminatory. And as my husband pointed out to me, that assumes that no one dies before they reach that age. But assuming that they're still alive, they said it's not arbitrary or invidious or unreasonable because social policy considerations, i.e. old people earn less and therefore are, you're doing a mitzvah, so to speak, to allow them to benefit from these discounts or increases in interest. Well, first of all, we're getting back to Judaism concept of justice and fairness. That may not be true. And the statistics show that while there's so many older adults have severe financial hardships, that is not necessarily, you can't say that obviously about everyone. And even generally speaking, we're going to do percentages, generalizations, that doesn't always apply. And to the extent that it does apply, i.e. older people need more money. If so, to some extent, it's because of the age discrimination, which prevents them from having a job or a good job to begin with. So it becomes, again, a self-fulfilling prophecy. And the other reason that the courts upheld these 2 instances of ageism was because on the concept that was encouraging and enabling citizens to enjoy life and the benefits of society as they reach old age. Well, that concept is to some extent an oxymoron, because by recognize or by premising the discount on the fact that they need help, you are denying them the one thing that may most important in their life at that point, which is self-respect. So first, it's not true. And secondly, it doesn't, when we talk about, as I did earlier, about honoring the elder, you don't honor somebody by saying, I feel so sorry for you, I'm going to give you something, a financial benefit. My all-time favorite case in this area involved a law that we had in California. This law no longer exists, the other 2 do. We had a law in California that said that if judges stay working past their 70th birthday and they die and they're married, their spouses are not entitled to any retirement benefits. In other words, they lose their retirement benefits by staying on the bench after 70 years. Now, this case, as I said, was written in 1984, so that's a really long time ago. And the judge who wrote it is now close to 80, if not over 80. He's still on the bench. But at that time, obviously, he was much younger, and he thought that that was just dandy to be able to terminate the retirement benefits because it promoted old people from staying on the bench. And his opinion said, okay, he actually said this, I admit it's a stereotype, but it's okay because it's ingrained in society and all it does is translate social attitudes into reality. And it could save money because if we had to go have a commission or a hearing every time somebody seems incapable of being on the bench, then that would take, this is just much easier. We'll just have a blanket rule and we don't have to go through on an individual basis. And it's not discriminatory because every judge who reaches 70 and is married is going to have the same thing happen to him or her. And then at the end, he justified it by saying there was a correlation, there could be, or actually there was, a correlation between age and ability. In other words, the older you got, the less capable you are. There are two new cases that came out in California, one in 2018 and the other is just pending now. It's just been filed. It hasn't been ruled on. Both involved age discrimination, but in favor of the young and not directed at the old. Although when you, like any discrimination, when you favor one person, you're discriminating and not favoring a person who doesn't fall into the same category. So in the first case, which was a 2018 case, the Tinder offered, does everybody know who Tinder is? I can't, or what Tinder is. I can't see your faces, so I don't know, but Tinder is a sex app or an app to hook up. I guess as my grandchildren would
Judge,
say.
it's effectively a dating app. I think it's probably the fairest way.
Oh, I know, but it's not as much fun to say it's a dating app.
That is true.
And from what my grandchildren tell me, it is what I just said, but thank you. Okay, so it's a dating app. And what Tinder came up with was to say, if you're under 30, you pay a certain amount to use our service. And if you're over 30, whatever the under 30 pays, you pay twice as much. And it substantiated that service or that offer by saying that younger users had lower incomes and less ability to pay for premium services. The court said not quite, and there's no independent justification for statutory, there's no statute saying what the policy considerations are that would defend this this age-based pricing system. So the other case, which is United Airlines, United Airlines is offering a substantial discount to people between 18 and 22. And as I said, that hasn't gone to court, but my guess is that case, if it follows the Tinder case, will not be, that discrimination will not be allowed because we have in California, as most states do now, a law, the Unruh Act, which says that no business establishment can discriminate on the basis of, and there's certain classifications, age being one of them. So if United Airlines said, we will offer a discount to anyone who's in college, which was what United Airlines said the purpose was, then that would have been upheld because college is not a protected category or classification. So what is the bottom line? What do all these cases say? Well, what they say is that the old are less qualified to take care of themselves, that the old need financial help, that we fulfill our duty as citizens and as a society to people, not by seeing them as a whole person, not by allowing them to work, but by giving them, letting them go to the movies for less money. What is the result, and why is this against the concepts of Judaism and age? Well, it promotes self-negative feelings. And as I said, it becomes a self-fulfilling prophecy. It, for example, justifies firing. We don't have to worry as a society about not hiring or firing older people because we're giving them the benefit by letting them go to the movies for less money. And in the case of the Tinder matter, sex is something that's really promoted within Judaism. There's even, laws about it, and the spouse's obligations one to another, mostly the man to the woman, and dating in Judaism recognizes that sex is more than just for procreation, and it's encouraged as one of the most special things in life, even when you're past the procreation age. So altogether, when you take this all together, these price discounts castrate the very essence of what it is that Judaism suggests, which is living not just a long life, but a fulfilling life. Thank you.
Thank you very much, Judge. That was fantastic. We have a couple questions we're going to go through now, and feel free to add some more either in the chat or the Q&A, and I'll go through them as appropriate. I think the first question is for Professor Alexander Kay. Can you give some examples of concepts from U.S. law or British common law that are grounded in Jewish law?
So this may not be this may be better for Justice Sonnenschein actually than for me, and I'd be actually really intrigued to hear her answers to
You guys
this.
can all chime in here, absolutely.
Yeah, please do. I would.
Okay.
Yeah, please go ahead, please.
No, I'll go after you.
I'm far more interested to hear what you have to say. Thank you.
Honestly, I think just about everything. I think I gave the death penalty example, and I know I've heard people say in my 50 years of being a lawyer and a judge, I've had 27 million people ask me, why do we have so many, why does it take so long for the death penalty? Why are there so many appeals? Why does it get to the point of, pulling the plug, so to speak, or giving the injection, and then the Supreme Court looks in? Why do we have to have all those lawyers involved? And if the Jewish law isn't clear on that, I don't know what is. If Jewish law says that every 80 years of killing somebody as capital punishment is too much, and also the Jewish underlying concept that I don't know what the number is. It's better to let one guilty person go free, or is it the opposite? Nine guilty people go free than execute or find guilty one innocent person. So that topic comes to mind. I think the whole concept of evidence, when Lynn talked about you can't just have one person testify. We can just have one person testify, but the rules of evidence are sacrosanct in terms of what's admissible evidence, what isn't admissible evidence. So you give me our environmental laws are based on the concept in the Torah of every 7 years. So is that good enough, Mr. Morris? David? You
Yes,
want more?
I think so. Professor Kay, do you want to add? You want to add to that, or?
Simply to say that I'm always intrigued when it comes to these things with questions of historical causation. So that when we see these kinds of overlaps, where and I'm sure there are the ones that the judge mentioned, and there I'm sure many others as well. As a historian, I'm always interested in trying to figure out, did these things find their way into American law because they were in Jewish law? And if so, what was the kind of historical connection there? Or is there some kind of independent causality that, you know, two legal systems came to similar answers for some reason or another? But there's no question that, and certainly the legal system of the United States is heavily based, of course, on the Christian past of this country, and certainly true in the United Kingdom also. And so, of course, so, you know, Jews and Christians share at least some of the scriptures, although they interpret aspects of them differently. So that's where I might look for some of the historical background to these things.
All right, thank you.
I'm just going to add one
Sure.
thing, David, and I'm going to put this into the chat for all of our people. This is an author. She's a law professor, Suzanne Last Stone, who has written some really interesting, really engaging articles about, for example, recent legal scholarship having a big tendency in the past few decades to turn to models in Jewish law to try to give a counterpoint to what they're seeing in US law. So this isn't like a one law professor does it, but that a lot of folks are using Jewish law as like a counterpoint to principles and processes in American law. The one point that Suzanne Stone makes is that whereas Jewish law makes a role for God, as Sheila was talking about, Stone argues that there isn't really a comparable place for God when you're trying to set up some of these structures in the US, in some of the US functions. So I'm sort of summarizing kind of an intricate legal argument, but that's a really interesting article to look at. Then the other piece, just because the questioner was asking about the common law tradition, and I certainly can't speak to particular aspects of the English common law that might have Jewish origins, but Suzanne Stone makes the point that common law as a way of developing law through cases and precedent is very much a useful structure for looking back at Jewish law, which is not necessarily kind of we don't think about it like with legislatures and then putting things into practice, but rather that the classical corpora of Jewish law, like the Talmud, are a lot, do include a lot of common law type legal material, which is cases that came before judges and how they ruled. So just a few other interesting aspects regarding the overlap with common law.
I have another comment if we have enough time. First of all, when God is used in civil law, whether it's American or British or whatever, to me, it's a cop-out. And that Bradwell case I talked about, I mean, I've cited that case and discussed it maybe 4 million times, and I never stop wondering at what I'm reading, because this is the United States Supreme Court, and the only thing they could come up with, and I'm not minimizing God at all, but the only thing that they could come up with is it's not God's way. And so that's telling unto itself. And in terms of Alex's question, you know, what's the significance, or how did we start relying on Judaism, on Jewish laws, and what's the similarities between our law and American law? I think whatever society's laws we're looking at, they are or should be focused on fairness. So if that is the keystone, the underlying foundation of Jewish law, then it's not surprising that that there's a continuation of that theme in American law. Secondly, because, as Alex and I both mentioned, because Judaism covers everything, again, it's not surprising that there is a Jewish law foundation for whatever it is that we're considering. And another example of that is the right to privacy. And as I understand it, when people were told how to erect their tents, it was always so that the entrances were this way. In other words, you weren't what couldn't see into the others. And that's to some extent the foundation for our libel and slander laws, and all the cases that we see now on invasion of right to privacy, to some extent, have their foundation in Judaism concept of privacy.
I'll move on to the next question. So the next question is the methodology of Jewish justice defined in the Bible anywhere earlier than Leviticus? And is Leviticus how you define how to judge? And the related question is there a fairness doctrine inherent in that?
Lynn, do you?
So are we talking about, for example, the idea that you shouldn't, which is I think what Sheila like specifically quoted that was inscribed in her Bible, that one of the biblical injunctions to judges is to not prefer the rich. So if the question is that some of the earliest material, that's certainly very early. You can get into what pieces of the Pentateuch might be earlier than others, but I would certainly consider biblical material the first level, and then anything from the rabbinic oral tradition to be after that. And I think that those recommendations are absolutely foundational, and that the classical rabbis go back to them again and again. I think another interesting thing that comes up biblically that the rabbis are very interested in regarding fairness is that you might not just prefer a rich thing. I think that you might prefer a poor person. In other words, the law is really trying to, the law presumes the judge can't take a bribe. Okay, so that's kind of like maybe preferring a rich person, but you might feel compassion and feel that it's going to be a hard thing to rule against a person who's already feeling pressure from other kinds of parts of their context. And so the Pentateuch also tries to show that the law has to stand with fairness to all, even if compassion makes one want to change it. So the rabbis are very interested in all of those things. And so if that's a question of whether that's one of the earliest, I would certainly say it's one of the earliest. And if you want to get into whether, how you want to compare the dating of Deuteronomy and Leviticus, we could do that during a Bible seminar.
Yeah, well, and Deuteronomy is the first to establish to say that you shall set up judges. And I find it interesting because you shall set up judges and law enforcement. And my husband and I had a conversation about this because I said I thought that was interesting, that first you have judges and then you have law enforcement. And he didn't think that was the least bit strange because he thought that you have to have the interpretation before you can enforce. And I'm thinking, no, first you enforce it, you say you've done something wrong, and then you bring it, that would be the natural thought, you bring it to the judge to interpret. But the Deuteronomy recognizes the significance of having the judge come before law enforcement, which is cool.
And if we're thinking about earliest kinds of law, and this isn't exactly about a fairness doctrine perhaps, but a question of natural law. And again, I don't know about whether this is historically proceeds or not, but it certainly proceeds in a theoretical basis. The Bible seems to assume some kind of natural law that is independent of and indeed precedes the law that's revealed to Moses on Sinai. So, for example, right at the beginning of Genesis, the whole world seems to sin, and God kills everybody with a flood. And in later rabbinical literature, the question is raised, like, on what basis does God judge the people if there's no law by which to judge them? I mean, there was no Sinai, there was no law. We don't see any explicit commandments that God gave the people to not murder or steal or whatever else. And the answer given by Nachmanides and others, as a medieval rabbi, is that there's a natural law that precedes any law that's given by God or that's legislated by human beings, which, you know, is just taken as given in any human society, and people have to be held to that. So in a way, Jewish law recognizes a law that precedes it, which is a natural law that applies not just to Jews, but to all human beings.
And the question, that the very fact that they're asking the question, how could there be punishment if no law was given? And the answer being there was law, means that the rabbis are ascribing to God a fairness, that people are not going to be retroactively, judged by laws given retroactively. That no, there had to be a law in place, and God would be judging according to that law in order for there to be punishment. That's a theology that's implicit there.
All right. I have two more related questions. I think these are really good ones. Thank you to the audience. So the first is, how much do biblical historians think that Jewish law, as codified in the Torah, was shaped by the legal conventions of other cultures coexisting at the time? And then the second question, which I think is related, is, what are the basic differences of law between the bodies of law of Judaism, Christianity, and Islam? It's a little chronological there.
I'm going to take the first part of that. There is very good comparative work which places the legal parts of the Pentateuch, so like the oldest part of the Hebrew Bible, or among the oldest parts of the Hebrew Bible, that places those legal parts in the context of other ancient Near Eastern legal codes. I have colleague Sarah Milstein, who does very interesting work on this, and you can look up her work. So first thing to say is that the Hebrew biblical law often parallels in many ways the laws of the empires in which it was, developing, and then also has some very interesting differences. So I'll give you an example of a parallel that you might not have thought of. I'm not going to go with eye for an eye stuff for a second. Did you know that having two heads of the year is not, like, for example, that Passover is sort of the head of the year because it's on Jewish month number 1, and then Rosh Hashanah, the Jewish New Year, is also a head of the year. Did you know that there are also two heads of the year in Canaanite, sort of ancient Canaanite laws? So that's something that we're not even going to go near criminal law to just say that there's a lot of overlaps between certain things, I guess you might call ritual law, and then also regarding criminal or civil ways of writing codes, use of case law, and then some actual similarities. And there are whole collections, if you can get yourself to kind of a more academic library, there are whole collections that place the biblical texts within ancient Near Eastern texts that are like them. So I'm going to put this in the...
You're muted.
Bill Hallow and others have this 3-volume wonderful collection of ancient Near Eastern legal documents and other documents if you want to see what looks like parts of Leviticus or parts of Deuteronomy. But there are differences, and they could be to do with inheritance, to do with punishments, to do with procedures. So it's a great area of comparative law that you can learn a lot more about. And I just want to say something about late antiquity, so the time when the rabbis are. Similarly, there is a great deal of knowledge we have now about how Roman law and rabbinic law that was coming in the Roman period might be similar. and then how later rabbinic law that was happening in the Sasanian, Babylonian, Mesopotamian context are similar to rules that Zoroastrian priests put into effect and also different. So I'll give you two examples. In the Roman context, there was a recent article by legal scholar, rabbinic scholar Orit Malka, who points out that the categories of people who are excluded from testimony in rabbinic law, like the people who bet on pigeons and other kinds, there's a sort of a category of a strange category of folks. And what brings all those people together? And Malka argues that what brings those together is a similar set of Roman moral ideas, that those people are not participating in the right way in what it would be to be proper Roman citizens. So by comparing Roman ideals and also Roman law, sometimes things in Jewish law become much clearer. That's Orit Malka's idea. And then in the Babylonian context, there's a new book by a guy called Shai Sekunda called The Talmud's Red Fence, where he compares very carefully Jewish laws of menstruation and how women observe purity and impurity to do with menstrual cycles and their families, and how the rabbis, in a context where the Zoroastrian practices were very, very, very strict, what did the rabbis do to react to those contexts and also make it clear that the Jewish people practice differently? So there's a lot of very interesting comparative work in both the rabbinics context and in the biblical ancient Near Eastern context to explore.
I see we're coming towards the end of our time, and I definitely would like Judge Sonnenschein to have the last word. So let me just say very, very briefly a word about the comparison of Jewish, Christian, and Muslim law. It's often understood that because because Christianity recognizes what Christians call the Old Testament, what Jews call the Hebrew Bible, and that Islam recognizes certain aspects of both Judaism and Christianity. For example, the prophecy of Moses, and Islam recognizes Jesus as a prophet as well. That there's some kind of connection between the laws of these three faiths, and indeed there are all kinds of ways of pointing at overlaps and similarities, and that could certainly be done. One thing to bear in mind is that when it comes to Jewish law, people who are non-experts in Jewish law often focus on the Bible as the source of Jewish law. And of course, the Bible is hugely important in Jewish law. But fundamentally, Jewish law is a rabbinical institution. In other words, of course, it's based in some respects on the Hebrew Bible, but it comes out of rabbinic interpretations of the Hebrew Bible. So even if the scripture is held in common, at least with Christians, the interpretation of the scripture is very often different. And in fact, this was something that Christians in the Middle Ages learned to their horror. Christians, according to the doctrine of Augustine, have been kind of happy having Jews around for a long time because they recognized them in the Middle Ages as people that sort of could preserve the witness of the truth of the Old Testament. And when Christian scholars found out that Jews cared about the Bible, of course, but the main basis for their legal institutions was the Talmud, it was greeted with tremendous horror. And in fact, a lot of pushback and violent oppression ensued as a result.
Excellent. Thank you for the context on that. Judge, anything you'd like to add before we wrap up? I realize we're coming.
Well, I noticed there was one one question that I don't think we specifically addressed. And it really is a summation of everything I had to say. And that is the discourse between Lynn's conversation about justice and fairness. And I have very strong thoughts about that. I think that at least in the system in which I operate, which is the California legal system, justice is the goal and fairness is the way we achieve that goal. And once you start substituting or equating fairness with what you deem as morally right or or practically correct or anything. You lose the whole concept of justice, because justice has to be based on the evidence, the facts, and the law. And once you go outside of that, you've destroyed the whole concept of civil justice. And there are far too many people in the United States today that don't appreciate that difference. And somebody wanted to know why the big deal about living close to the wall. I don't know if you're still on the call, but the big deal was that the closer you lived to the wall, the better protected you were. And also so that was a premium, as it would be in the communities that I discussed, which it's how close you are to the ocean or how big your house is.
Thank you. That's fascinating. I was actually wondering that one as well. Listen, thank you. Thank you, everyone. You just did such an amazing job. This was fascinating. I can say I learned quite a lot tonight. So thank you for taking your time out of your busy schedules to be here with us tonight. Thank you for such a large crowd here on Zoom. We really appreciate your engagement with the Brandeis community in this great learning event. And we'll look forward to seeing you all at another upcoming Lawyers Network event, hopefully in the very early 2021. Thank you all very much, and good night.